If you are ever involved in a family court custody case, there is something nobody will tell you until it is too late. The judge has already read everything before you walk in. Every statement, every counter-statement, every exhibit, every letter. He has read it all, he has formed a view, and in most cases that view does not change. I'm telling you this not to frighten you. I'm telling you this because what happened in my case was so far outside the normal pattern that my own solicitor stood up and said she had never seen anything like it in 17 years of family law. My daughter is called Iris. She was 4 years old when the proceedings began. She is 6 now. In those 2 years I learned more about the family court system than I ever wanted to know. Most importantly, I learned that judges are human beings. They get tired. They carry their previous cases into the room with them. They make decisions based on incomplete information, because incomplete information is all anyone ever has. And occasionally, very occasionally, one of them surprises everyone. For the first 2 hearings, things went as expected. The CAFCAS officer recommended primary residence to end pending further assessment. The judge agreed. I was patient for 11 months. I attended every contact session. I never cancelled. I never arrived late. I kept a log. I communicated only through official channels. I attended every parents' evening, every school event, every medical appointment I was permitted to attend. I documented everything. N meanwhile had moved. She had enrolled Iris in a new school without informing me. She had cancelled 3 contact sessions citing illness, then posted photographs of herself and Iris at a theme park for her taken on one of those dates. I had all of it. The final hearing was listed for a full day. N went first. She was confident. She described me as a peripheral presence in Iris's life. Then the CAFCAS officer gave her updated recommendation. Continued primary residence with N. No shared care at this stage. N exchanged a look with her barrister. It was the look of people who believe the outcome has already been decided. The judge shuffled his papers. He looked at his notes, and then he put his notes down. He said he had a concern he wished to raise before he gave his ruling. He said that in reviewing the bundle he had noticed something that had not been addressed in evidence by either party. He had found 17 emails from me to N regarding Iris, emails about school events, about medical appointments. He noted that all 17 had been read. He noted that none of them had received a reply. He looked at N's barrister and asked whether his client wished to offer any explanation. There was a long silence. N's barrister said his client had no comment at this time. The judge nodded. He picked his notes back up. Equal shared residence. Week on, week off. Immediate effect. My solicitor leaned across and squeezed my arm. She said she had never seen a judge do that in 17 years. I picked Iris up from school that Friday. She ran across the playground and said, "Daddy, I packed my own bag." I said, "Did you remember your rabbit?" She said of course she did, because she was not a baby. She is 6 years old. She is the sharpest person I have ever met.